you.
Good morning, Mr. Smith.
Good morning, Your Honors. If it pleases the Court, my name is Greg Smith. I represent the plaintiff appellant in this matter, Mary Bishop. Your Honor, we're here on appeal from a trial and a directed verdict in favor of the defendants. The primary issue before the Court is whether Massachusetts General Laws, Chapter 186, Section 19, applies to commercial leases. I believe the answer to that question is yes, it does. If we look at the first sentence of Section 19, it states, and I quote, "A landlord or lessor of any real estate." And that's the key language here. The legislature is not making any distinction between a residential landlord and a commercial landlord. The fact that they use the words "of any real estate" infers that they meant it to imply that Section 19 should apply to a commercial landlord. This Court recently, in fact, in April of this year, decided the case of Norfolk and Dedham Mutual Insurance Company versus Morrison, a case in which Attorney Feeney, in fact, represented the appellee, Norfolk and Dedham Mutual Insurance Company. The Court decided in that case, Massachusetts General Laws, Chapter 186, Section 15, did apply to a commercial landlord. The fact that the legislature did not, and in fact that statute applies to the avoidance of certain contractual obligations between a landlord and a tenant, and the Court decided in that case that it in fact did apply to a commercial lessor.
So the practical effect of what you provide is that if there is an agreement between a commercial landlord and a tenant, whereby the tenant agrees to take sole responsibility for all repairs, the tenant still can write a certified letter to the landlord and say, I've got a dangerous condition in my leasehold and I want you to fix it. And the landlord says, wait, you contractually agree that you're responsible for those repairs, and the tenant can waive Section 19 and say, yeah, but I've written you a letter, now you have to do it.
Well, it's a factual question, Your Honor, and I would suggest that it goes to the lease itself. In this case, we have a commercial lease where the tenant has agreed to make repairs to fixtures.
Right, but the problem is, I understand there may be some ambiguity in your lease, but Section 19 says any waiver of this provision in any lease or rental agreement shall be void and unenforceable. So even if it's clear as day that the tenant is responsible for all repairs under this section, that's null and void.
Your Honor, except that we're dealing with a structural repair, a repair to the building. This case involves a repair to the roof.
But are you saying then that it doesn't, if you just take the lease, that the roof isn't included in what?
I am saying that. If you look at the terms of the lease, it clearly states under Section 19 of the lease, which you have in the record appendix, that the tenant is responsible for all repairs, maintenance of the fixtures. That involves the electrical, the conduit. It does not involve structural repairs to the building itself.
Well, but the statute talks about unsafe condition. You just mentioned electrical. What happens if the conduit box or the fuse box is old and rusty and its sparks are flying out of the thing? It's an unsafe condition. Who has responsibility under Chapter 186, Section 19 for making that repair?
Again, I would suggest, Your Honor, that you have to look to the lease. If the tenant has agreed to accept responsibility for making repairs to all the fixtures, it would be the tenant's responsibility.
But why isn't that void under the terms of 186.19?
Because, Your Honor, the tenant has agreed to make those repairs.
But the statute says any waiver of this is void and unenforceable. It's as a matter of law, it's no good.
Except that that doesn't apply to the facts of this case, Your Honor. This case would not be on appeal if we weren't dealing with a case where the injury that was caused here was from the roof.
No, but you said...
I think the answer that you want to give Justice Spina is, yes, it would be void. You're the tenant.
I would agree, Your Honor. It would be void. If it was something that the tenant had agreed to repair at the signing of the lease, then it would be void. That is not under the case. That is not under the facts of the case we have here today. We have a roof, a structural repair that needed to be made. The tenant in this case did not agree to make those repairs.
Okay. Does Chapter 186, Section 19 only require that the landlord undertake to make the corrections? Let me ask you differently. Does 186.19 only render void and unenforceable a provision that the landlord not undertake to make the corrections, or does it also render void and unenforceable the cost of making those? And what I'm trying to get at is, in this case, notice was given that the roof was leaking, does that mean that the landlord under 186.19 may have had the obligation to, in the first instance, to make the repairs, but the cost of making those repairs would be recoverable against the tenant because the tenant agreed under the lease to do that?
Again, I think that's a case-by-case basis.
Well, that's this case, isn't it?
Well, there's no suggestion and there's no evidence before the court that the tenant in this case had agreed to undertake repairs to the structure of the building. In fact, the terms of the lease said she agreed to make repairs to the fixtures, to the internal mechanisms of the building. We have a tenant here who has taking over a business, a tanning business. It's a one-floor, small, mom-and-pop type business. And under the terms of the lease, she agrees to make repairs. If I insert anything, I put in any fixtures, tanning bed, I'll make repairs. I did not agree to make repairs to the roof of your building. I am not the owner of this building.
What the lease says is the tenant, at his expense, shall make all necessary repairs and replacements to the leased premises. And then it goes on to say, including. But if you just take that first clause, wouldn't that include the roof?
It does not, Your Honor, because if you keep reading on, the terms that are mentioned are fixtures. They are not structural repairs. This court in the case of Augustanowicz versus Bradley made that distinction when it found that the tenant in that case had signed a commercial lease, a net lease, which used the following terms, that the tenant shall be responsible for all repairs, both, quote, structural and otherwise. Whether this lease in the instant case is silent on that issue would be a question, and I think it is silent. But that burden should be on the owner of the building rather than the tenant. The tenant here is leasing the premises. There is no financial incentive for them to make repairs to the structure of the building. That responsibility should remain with the owner. With regard to the evidence in this case that the owner had in fact made repairs to the roof, there is substantial evidence in that the owner in 1996 had hired a professional contractor to make repairs to the roof. When my client moved in 1998, she informed the landlord that the roof was leaking. On at least 2 occasions, the owner went up on the roof, attempted to make the repairs herself through her husband. Those repairs were ineffectual. This roof continued to leak for 4 years before it caved in on the tenant.
Could I
Yes, Your Honor.
What's the evidence of causation? That is, that the ineffective repairs were the cause of the particular piece of ceiling that fell into your client's eye?
Your Honor, the fact that a professional repair man was hired in 1996 by the landlord would give an inference and allow a jury to conclude that the roof had problems as early as 1996. Subsequently, on at least 2 occasions, the landlord went up onto the roof and attempted to make repairs herself. Those repairs were, again, ineffectual. The evidence and in the record appendix suggests that the water continued to leak, and this is 4 years into the tenancy, before the roof caved in.
I think there's no question that your tenant could have walked away from this lease because the leaking made the conduct of her business not really doable, right?
I would agree that this would be a
Mr.
concern.
Wesson, whatever, could have walked away.
Correct. Correct. That this is, in fact, a substantial interference with the nature of her business, which would allow her to void the lease. That's not what happened in this case. She attempted to have the landlord make adequate repairs to the roof so that her tanning business could continue. And in fact,
Was the lease still in place, by the way? I thought
the lease had expired. It was a short-term lease. It was only for 9 months, Your Honor. And however, my client continued to make the monthly payments up until the time of this unfortunate
So does it
accident.
become a month-to-month tenancy, or
It did become a month-to-month tenancy. I would agree with that.
Now, there was evidence below that you alluded to before that the landlord had gone up on the roof more than just once, a couple of times to check out, actually made a repair, but continued to go up on the roof and investigate. How was that evidence presented to the court? Under what theory was that evidence presented to the court? Was it presented as evidence that the landlord undertook to make repairs and did it negligently, or was it presented along the lines or to support an argument that there was an ambiguity in the lease as to whether or not structural repairs were included, or both?
I would suggest it was made under both, Your Honor. Under this court's ruling in the Humphrey v. Byron case.
No, I mean, how was it actually presented to the trial judge?
It was presented by testimony from the tenant.
Now, what theory was presented?
Under that the landlord had contracted to make repairs and made them negligently, and that she had exercised control over the roof itself.
Was there any theory that this is evidence that structural repairs were never intended to be included under the terms of this lease?
Well, no, not direct evidence, but I think the inference is clear that and one would argue that
Did one argue that? Did one argue that to the trial judge?
That was suggested to the trial judge, yes, and the trial judge disagreed. The trial judge suggested that a gross negligence standard would need to be applied, and it was agreed that there was no evidence of gross negligence on the part of the landlord, only ordinary negligence, that for 4 years she had been attempting to effectuate repairs, that she did not hire a professional contractor to make these repairs, and that in effect that was not a reasonable way to repair the roof.
Mr. Smith, let me ask you this. If we look at 186, Section 19, it talks about an unsafe condition not caused by the tenant. I think of lots of leaky roof situations which are not unsafe. So in determining what, if any, obligations the landlord has, do we look to the condition unsafe with respect to that particular lease? Because I take it here it was because there was electrical equipment or something.
Yes, Your Honor.
And how do we know that we have to look at the particular real estate at issue?
I believe I would suggest it would be a common sense approach, Your Honor, if one were to tell their landlord that the roof is leaking and it's interfering with my business.
That's a different issue. That's not unsafe. Right? I mean, is there anything in the record that said this is unsafe?
Well, unsafe, you mean personally as an injury?
Well, I'm looking at an unsafe condition. I can think of lots of negligence. Let's assume this landlord agreed contractually to repair the roof. I'm not interested in that. I am interested in the application of the statute. And there are lots of, leaky roofs where there's damp and mold, but it's not unsafe.
Again, I think that becomes a question of fact, Your Honor, as to what is unsafe. Mold in that case would certainly be unsafe, I would think, for one's health.
Was it argued below that the water was falling onto the tanning booths, which were electrical, and they could short out?
Absolutely, Your Honor.
Was it argued that that was unsafe?
It was, Your Honor, and in fact, the letter, which we say complies with 18619, in fact, refers to that very condition. Not only was it unsafe that someone could be potentially electrocuted in this business, it was also affecting detrimentally the business itself. And in fact, this case, the roof did cave in. I think it's clear that if you're letting a roof leak for 4 years, that may cause some structural or damage the structural integrity of the roof, where it may not, but it could fall in and collapse, which in fact it did in this case.
Thank you, Mr.
Thank
Smith.
you.
Good morning, Mr. Feeney.
Good morning, Your Honors. May it please the Court, Robert Feeney for TES Realty, and I'm here with Ann Payon. This is a case where, at least in part, we agree. I certainly believe that the 18619 does apply in the commercial landlord context, but where we depart...
It does?
I believe it does.
Okay.
Under a number of cases out of this court dating back 30 years.
So what's the landlord's responsibility in this case?
In this case, Your Honor, there is no responsibility because the proper construction of 18619 indicates that it triggers only where the landlord has reserved in a lease the duty to maintain. I'd respectfully submit that under 30 to 50 years...
Yeah, but doesn't it say that you can't waive that duty?
It does say that, Your Honor, but it also says that it provides for liability of a commercial landlord only if it's an unsafe condition not caused by the tenant. That's the operative phrase. I respectfully submit that whereas here, where you have a commercial tenant who negotiated with a commercial landlord for the occupancy of the entire premises, and all we need to do is look at Section 2 of the lease to see that the leased premises is the entire building. Just as in Augustinowitz, there's no common area here. It's the tenant himself who took on all of the duties and obligations of an owner. And in this case, it cannot be said that there was any unsafe condition that was not caused by the tenant. The tenant was operating the business out of this building as the owner of this building. She had agreed, after negotiating with a commercial landlord, to take on all of those obligations, as you'll see in the lease.
But the statute contemplates that, doesn't it? It says that reasonable care to correct the unsafe condition described in said notice, except that such notice need not be given for unsafe conditions in that portion of the premise not under the control of the tenant. If the premises are under the control of the tenant, the notice has to be given.
Well, Justice Peter,
here the notice was given.
I respectfully submit that provision that you're citing to concerns the requirement of notice. It doesn't indicate when the statute comes into play. I respectfully submit the operative phrase must be it comes into play, the statute is triggered any time there's an unsafe condition not caused by the tenant. To construe the statute otherwise would rewrite thousands and perhaps tens of thousands of leases where commercial parties have carefully negotiated what burdens and obligations the landlord and the tenant is going to have. As Your Honors have already pointed out, I need not hire a lawyer anymore to negotiate a commercial lease because it doesn't protect me as a commercial landlord. Anytime I have a 15 or 20 page lease that I've taken time, care, and expended resources to negotiate, all a commercial tenant need do is send me a letter and say, hey, there's an unsafe condition here. I understand that I contracted to maintain this entire premises. I understand by virtue of paragraph 2 that it was me that was going to take all those obligations on. But now I'm going to send you this letter, and this lease is meaningless as far as the duty to maintain.
It may be meaningful in the sense of who is responsible for the cost, but it may be that the statute said, look, if there are unsafe conditions, somebody's got to do it, and it seems to us that the owners of the buildings ultimately are responsible for unsafe conditions as opposed to other kinds of unfavorable conditions.
I respectfully submit, Your Honor, that it's an unworkable standard, because that would mean that even defects inside the demised premises, let's say, for instance, I rented a 30 or 50,000 square foot warehouse. If my tenant erected shelving improperly, wasn't attached properly.
Well, that would be caused by the tenant.
Well, it would be
It's this is unsafe conditions not caused by the tenant. The tenant's use of the property may create an unsafe condition, but that's not what this statute is dealing with.
I'd respectfully submit that the tenant's use may cause an unsafe condition.
But how did
Just
the,
as-
how
I'm sorry.
did the, just help me understand
Yes,
how
ma'am.
the leaking roof was caused by the tenant.
Well, I'd respectfully submit that, Your Honor, that where a tenant occupies an entire building, as this court has ruled in the past in Humphrey v. Byron, and has knowingly negotiated a lease where the tenant takes on the burdens of ownership.
So you're
that-
saying the failure to rectify the leaky roof is really, it's an omission by the tenant.
I sure am, Your Honor. And I respectfully submit that even reasonable wear and tear of a commercial building where the tenant has taken on the obligation is a defect or an unsafe condition, at least potentially, that's caused by the tenant and not by the owner.
But isn't the landlord usually in the best position to at least to make those repairs in the first instance, and from a financial point of view? And that's why this statute exists, that whoever may be financially responsible ultimately, it's the landlord that is in the best position to make the initial fix, and he should do that, should undertake that.
I think, Your Honor, in a residential context, that's true without doubt, and that's why this court so often has distinguished between commercial tenancies and residential tenancies. I don't think, however, where you have two businesses, and these are people who've been engaged in business for years. They took time and care to negotiate their respective obligations. This is not a situation necessarily where the landlord had any greater resources than the person that was operating a business out of this small building. These are a couple of parties who are sophisticated in their dealings, and they've taken the time to decide amongst themselves which of the two parties is going to have the duty to maintain. I think
So why did the landlord undertake to make repairs in 2001 and then go up and look at the roof again a couple times after that?
Well, there's a factual dispute about that, and I understand that the court must draw that.
Yeah, so if there's
in
a
favor
factual
of-
dispute, why was judgment entered?
Well, it's not a factual dispute that's of any legal import, I'd respectfully submit.
Why?
The testimony here was that the husband of the owner of the building went up and made repairs at least once. There's a dispute about whether it was once or twice. But the testimony is that he did so under the default provision of the lease, and this is no different than any number of cases that this court and the Massachusetts Court of Appeals has decided, where it was determined that where there was a default provision in a lease and a landlord was motivated to maintain its investment, then that landlord was entitled to go up and make repairs. I'd respectfully submit, however, that does not create a duty under either common law or 186.19. And to Justice Botford's issue, there is no evidence here of causation. This is not a case where somebody walked into a courtroom and said, well, repairs were made 7 or 8 months before this incident, and it was something that repairman did or failed to do that caused this incident. There's no causal connection here between anything that this man did up on the roof 7 or 8 months before the incident and the happening of the incident itself. And while I understand that the court's instructions are that generally negligence cases should be decided by the fact finder because they're so fact intensive, this court and the appeals court has held a number of times where there cannot be any reasonable determination by a jury as to causation or any other element of the common law claim, that the claim fails as a matter of law. And that's what the judge saw here. I'd respectfully suggest that it was the correct decision.
Could I ask you a question about
Yes.
that? Assume that to be correct, the judge was applying a gross negligence standard.
Yes,
right?
Your Honor.
Well, assume for the minute that in 2010, there's a view that these distinctions between gross negligence and ordinary negligence don't make any sense.
Yes,
that
sir.
actually it's ordinary negligence. Does that mean we need to send it? It has to be a retrial because the wrong standard was used?
I don't believe it does, Your Honor. We're here obviously on a de novo basis, and I respectfully submit that there's nothing in this transcript from which a jury could reasonably conclude that anything that this repairman did 7 or 8 months before the accident caused this incident. You'll see, I believe at page 65, Your Honor, and I could be off by a page or two, that the undisputed testimony in this case was that the repairs which were made were to the other side of the roof from where the accident allegedly occurred. And even the plaintiff herself testified that when those repairs were made in a place remote from the place where the alleged defect was present, that the leaking stopped. Given those circumstances, a jury necessarily would have to rely upon conjecture to somehow relate. I'm sorry?
Was this a flat roof?
I believe it was, yes. I believe it was a flat and a rubber membrane roof. I'd respectfully submit that there is no common law claim, whether we apply the gross negligence standard or the ordinary negligence standard. I would respectfully submit that while the court has eliminated status distinctions, this court has indicated in cases like those involving sports or duties to trespassers that there are circumstances where we should apply a different standard than ordinary negligence. I'd submit that this is one of them. The court should continue to adhere to the standard of gross negligence because we don't want to discourage landlords from making repairs if they see something untoward.
You began your discussion by saying that you agree that Section 19 does apply to this property, correct?
I hope I didn't say that, Your Honor. What I meant to say was that I agree that 18619 can apply in commercial landlord tenancy.
Okay. And with regard to this property, would?
With regard to this property, absolutely would not, because, Your Honor, this is
it would apply, but it's not triggered here because
Correct.
of the terms of the lease.
That's correct, Your Honor.
And did the judge below have that view when he directed the verdict?
Your Honor, it's not clear to me from reading the discussions at sidebar what the subjective belief of the hearing judge was, but I'd respectfully submit that his decision was the correct one. I'd respectfully submit that the appeals court got this issue right when it decided 20 years or so ago in Augustinowitz that where you have a tenant who occupies the entire building and takes on the duty to maintain, that this statute is not triggered because any condition resulting from the tenant's own failure to comply with the obligations that he's taken on by lease is not the responsibility of the landlord. And more to the point, is not an unsafe condition not caused by the tenant.
But under that argument, even if there was a latent defect and there was damage that arose on the very first day of the tenancy, under your theory, the tenant's responsible for not having repaired that defect, even though it's a latent defect.
I believe that's the case, Your Honor. Here, we had a tenant who had the opportunity, presumably, to inspect this property and who signed a lease indicating that she was accepting the property in good repair. And she said, as one of the justices pointed out earlier, that at her expense, she shall make all necessary repairs and replacements to the leased premises.
But that means that when, under your theory of Section 19, whenever the tenant agrees to repair the property or maintain repairs, that Section 19 does not apply.
Correct, Your Honor.
And then, so why would the legislature, if that were the case, include the sentence that says any waiver of this provision is void and unenforceable when, in fact, you can effectively waive this provision by having the tenant agree to be responsible for repairs?
Well, Your Honor, I don't believe that this is a case of waiver. I think it's a matter of, with all due respect, a matter of proper statutory construction. The legislature here made a determination that it was only the landlord's, it was only conditions resulting from the landlord's.
I understand, but you're basically saying pragmatically that the legislature took away with the left hand what it gave with the right.
Well,
that it makes it seem as if the landlord is responsible in all circumstances and can't agree otherwise, but in fact, that's not really the case. If the tenant agrees with it, this statute basically doesn't apply.
I don't think that's the case, Your Honor. For instance, if we were dealing with a shopping mall here, and there were common areas, and the landlord agreed to maintain those common areas, I'd respectfully submit that to the extent there was an unsafe condition on the common areas, which the landlord agreed to maintain, there would be liability under 186.
No, but that's not answering Justice Gantz's. That's not answering Justice Gantz's question, because his question is: let's assume that the landlord, in that case, had, you've got a shopping mall, you've got 10 tenants, and there's a provision that says, as to any areas, any unsafe conditions in those areas will be borne 1/10 by each tenant. In other words, moving the landlord's liability, potential liability under 186 Section 19 out.
Yes, Your Honor.
You say that's okay?
I don't think that is okay, and I'd respectfully submit it's not an appropriate way to handle such issues. The problem with that construction, Your Honor, is that instead of having the party responsible for maintenance before the court, we would have 9 or 10 blameless tenants, and we'd have cross-claims amongst all of those tenants. Our judicial resources are scarce enough without allowing somebody who owns a commercial premises to bring in 9 or 10 tenants. That's not this situation. This situation is where there were negotiations for one building, one premises, tenant agreed to maintain them. On these facts, Your Honor, I'd respectfully submit that the appeals court had the right analysis. 186.19 is not triggered, and I would respectfully ask you to uphold the entry of directed verdict in favor of TES Realty.
Thank you, Mr. Feeney.
Thank you very much.